Code of Professional Responsibility, Canon 19. A lawyer shall represent his client with zeal within the bounds of the law. In the discharge of his duty of entire devotion to the client's cause, a lawyer should present every remedy or defense authorized by law in support of his client's cause, regardless of his personal views. While a lawyer owes absolute fidelity to the cause of his client, full devotion to his genuine interest, and warm zeal in the maintenance and defense of his rights, he must do so only within the bounds of the law. In the case of Chowa versus Chongson, the petitioner on 1989 before Notary Public Filomeno B. Tan Jr. for his petition for naturalization stated that his wife and kids were residents of Malaspina Street, Bacolod City. Petitioner wife filed a case of perjury against him since she and their children have been living in different address for 5 years prior, and that petitioner had a paramour and 2 more children with the same since 1984. During trial, petitioner claims that he had already withdrawn his petition for naturalization, therefore making such functus officio or no further official authority or legal effect. The issue in this case is whether or not a withdrawn perjured petition for naturalization can still be admissible in a case of perjury. This is the ruling of the court. As to the complainant's claim that the withdrawal of the petition makes it functus officio, we sustain the respondent judge's view that the petition can be used as evidence in another case. In the case of People of the Philippines versus Cainglet, the court held that every interest of public policy demands that perjury be not shielded by artificial refinements and narrow technicalities. For perjury strikes at the very administration of the law. It is the policy of the law that judicial proceedings and judgment shall be fair and free from fraud, and that litigants and parties be encouraged to tell the truth, and that they be punished if they do not. The withdrawal of the petition for naturalization did not and cannot amount to a recall of the questioned untruthful statements. Neither could it extinguish any offense which may have been committed by reason of such untruthful statements. As an officer of the court and its indispensable partner in the sacred task of administering justice, graver responsibility is imposed upon a lawyer than any other to uphold the integrity of the courts and to show respect to its officers. This does not mean, however, that a lawyer cannot criticize a judge. A lawyer's duty is not to his client, but to the administration of justice. To that end, his client's success is wholly subordinate, and his conduct ought to and must always be unscrupulously observant of law and ethics. In the case of Maglasang versus People of the Philippines, Calixto Maglasang was convicted in the court in San Carlos, Negros Occidental. His counsel, Attorney Castellano, filed for a petition for certiorari through registered mail. Due to non-compliance with the requirements, the court dismissed the petition and a motion for reconsideration. Attorney Castellano then sent a complaint to the office of the President, where he accused the 5 justices of the Second Division with biases and ignorance of the law or knowingly rendering unjust judgments. He accused the court of sabotaging the Aquino administration for being Marcos appointees and robbing the Filipino people genuine justice and democracy. He also said that the Supreme Court is doing this to protect the judge who was impleaded in the petition and for money reasons. He alleges further that the court is too expensive to be reached by ordinary men. The court is also inconsiderate and overly strict and meticulous. When asked to show cause why he should not be cited in contempt, Castellano said that the complaint was constructive criticism intended to correct in good faith the erroneous and very strict practices of the justices concerned. He also said that the justices have no jurisdiction over his act and that they should just answer the complaint. The Supreme Court found him guilty of contempt and improper conduct and ordered to pay 1,000 pesos or imprisonment of 15 days and to suffer 6 months suspension. The issue in this case is whether or not the Attorney Castellanos acts constitute a violation of the provisions of the Code of Professional Responsibility. The court found his comments scurrilous and contumacious. He went beyond the bounds of constructive criticism. What he said are not relevant to the cause of his client. They cast aspersion on the court's integrity as a neutral and final arbiter of all justiciable controversies over it. The explanation of Castellano in his negligence in the filing of the petition for certiorari did not render his negligence excusable. It is clear that the case was lost not by the alleged injustices Castellano irresponsibly ascribed to the members of the court, but his inexcusable negligence and incompetence. As an officer of the court, he should have known better than to smear the honor and integrity of the court just to keep the confidence of his client. Also, with the complaint he filed, the most basic tenet of the system of government, separation of power, has been lost. He should know that even the President of the Philippines can pass judgment on any of the court's acts. Rule 19.01. A lawyer shall employ only fair and honest means to attain the lawful objectives of his client and shall not present, participate in presenting, or threaten to present unfounded criminal charges to obtain an improper advantage in any case or proceeding. Under this rule, a lawyer should not file or threaten to file any unfounded or baseless criminal case or cases against the adversaries of his client designed to secure a leverage to compel the adversaries to yield or withdraw their own cases against the lawyer's client. In the case of Pena versus Aparicio, this is an administrative case for violation of the Code of Professional Responsibility against the respondent, Attorney Lolito G. Aparicio. Respondent appeared as legal counsel for Grace Hofana in an illegal dismissal case. This complaint rooted out when herein complainant Fernando Martin O. Pena sent notices to Hofana for the latter to explain her absences and to return to work. In reply to his return to work notice, respondent wrote a letter to complainant reiterating his client's claim for separation pay, in which the letter also contained threats to the company. Moreover, believing that the contents of the letter deviated from accepted ethical standards, complainant filed this administrative complaint. The issue in this case is whether or not respondent's acts constitutes a violation of the Code of Professional Responsibility. The Supreme Court relied on Canon 19 of the Code of Professional Responsibility. It states that a lawyer shall represent his client with zeal within the bounds of the law. Furthermore, Rule 19.01 commands that a lawyer shall employ only fair and honest means to attain the lawful objectives of his client and shall not present, participate in presenting, or threaten to present unfounded criminal charges to obtain an improper advantage in any case or proceeding. In the case at bar, respondent did exactly what Canon 19 and its rule proscribed. Through his letter, he threatened complainant that should the latter fail to pay the amounts they proposed as settlement, he would file and claim bigger amounts including moral damages as well as multiple charges such as tax evasion, falsification of documents, and cancellation of business license to operate due to violations of laws. The threats are not only unethical for violating Canon 19, but they also amount to blackmail. Notwithstanding, respondent does not find anything wrong with what he wrote, dismissing the same as merely an act of pointing out massive violations of the law by the other party and with boldness asserting that a lawyer is under obligation to tell the truth, to report the government commission of offenses punishable by the state. He further asserts that the writing of demand letters is a standard practice and tradition, and that our laws allow and encourage the settlement of disputes. The Supreme Court ruled that indeed the writing of demand letters is a standard practice and tradition in this jurisdiction. It is usually done by a lawyer pursuant to the principal-agent relationship that he has with his client, the principal. Thus, in the performance of his role as agent, the lawyer may be tasked to enforce his client's claim and to take all the steps necessary to collect it, such as writing a letter of demand requiring payment within a specified period. However, the letter in this case contains more than just a simple demand to pay. It even contains a threat to file retaliatory charges against complainant which have nothing to do with his client's claim for separation pay. The letter was obviously designed to secure leverage to compel complainant to yield to their claims. Indeed, letters of this nature are definitely proscribed by the Code of Professional Responsibility. Wherefore, premises considered, the petition is granted. The 26 May 2006 resolution of the IBP Board of Governors is hereby reversed and set aside. Respondent Attorney Lolito G. Aparicio is hereby found liable for violation of Rule 19.01 of Canon 19 of the Code of Professional Responsibility and is accordingly meted out the penalty of reprimand with a stern warning that a repetition of the same or similar act will be dealt with more severely. Duty to advise candidly. As officers of the court, counsels are under obligation to advise their clients against making untenable and inconsistent claims. The counsel should inform his client and dissuade him from filing the case if it is totally devoid of merit. If he finds that his client is fairly meritorious and ripe for judicial adjudication, he should refrain from making bold and confident assurances of success.